In the 1950s, the public schools, even in places like what is today progressive Arlington, had been places of what attorneys would describe as subjected to a de jure segregation, with a discriminatory effect imposed under the force of the law, quite distinct from de facto segregation, where things are just as it says, a matter of fact. And some may know the story of a 7-year-old girl named Linda Brown in Topeka, Kansas, who had a case that had gone all the way to the United States Supreme Court for a landmark decision written by Chief Justice Earl Warren in 1954, which had declared that education is perhaps the most important function of state and local governments, considered to be required in the performance of our most basic public responsibilities, and the very foundation of good citizenship. It was Chief Justice Warren's progressive thought back then that it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education, and that such an opportunity, where the state had undertaken to provide it, is a right which must be made available to all on equal terms. But on March 13, 2020, despite that right, with a total of only 5 reported cases of COVID-19 in Arlington, Virginia, less than 45 cases in the entire state, and not even one fatality yet in the entire state of Virginia, before even the Virginia governor or medical doctor had issued any order or proclamation, the Arlington Public School Board had announced that it would be closing the schools, which produced some protest in the form of online petitions from some children who had been concerned about missing proms and graduation ceremonies, or the very things about which one might reasonably expect a child to deem most important. And as the Bible says in what is often called the love chapter, when I was a child, I spake as a child. I understood as a child. I thought as a child. But when I became a man, I put away those childish things. And in 1950 in Topeka, Kansas, it was not a 7-year-old named Linda who rode a bus all the way to the other side of town to a dilapidated schoolhouse, or even her 2 younger sisters in an ethnically diverse neighborhood who decided to get themselves an attorney and brought a complaint about inadequate educational facilities. But rather it had been the organizational efforts of the NAACP that had approached her parents to give them the idea. Reverend Oliver Brown and his wife Leola, who had asked a group of African-American parents that included Reverend Brown to attempt to enroll their children in all-white student schools with the expectation that they would be turned away, creating conditions to establish standing in a court of law for an actual and direct injury, not speculatory damages that have been traditionally eschewed by the courts, and someone who was thinking like a lawyer to build a case. Very deliberate. And Reverend Brown took the advice of the NAACP to attempt to enroll his 3rd grade daughter Linda at the Sumner Elementary School in Topeka, Kansas, a part of a grander strategy that would include a total of 13 families from different states. And 3 years later, the nation's highest court in the land would do so with Brown, who was in the 3rd grade at the time and barred from enrollment at the Sumner Elementary School. The strategy was for the civil rights group to file a lawsuit on behalf of the 13 families who represented different states, and a year later, in Brown v. Board of Education 2, Chief Justice Warren had ordered that the cases are hereby remanded to the district courts to take such proceedings and enter such orders and decrees consistent with this opinion as are necessary and proper to admit to public schools on a racially non-discriminatory basis with all deliberate speed the parties to these cases. That was an order that was resisted in the County of Arlington for 5 years. That was a decision that Arlington was so determined to resist that they replaced the entire school board. And it took another mandate from the court to force them to desegregate the public schools. But despite the fact that the Supreme Court had recognized the right to an education, not even one parent in indivisible Arlington, or even the NAACP, did what had been done in Topeka in 1950, and brought a case about the rights of children who have somehow summoned the civic engagement skills to demonstrate and protest about guns in schools, equal treatment for transgender students, the changing of school names, and even the conflict in the Gaza Strip, raising a reasonable inference of suspicion, at least as to how these landmark changes actually occur in making history, if not historically done by children just making up their minds to protest. My name is Major Mike Webb. I was the son of a pastor and an educator who was the president of a local chapter of the NAACP. I've been the child protege of his friend, a legendary civil rights and criminal defense attorney who had also been a president of the local chapter of the NAACP. I'm the godson of a man who was not only a pastor, but also who would become the president of the United Negro College Fund after serving as the first African-American House Majority Whip in the U.S. Congress. And one friend of my father with whom I had shared a spiritual mentor. Long before he had ever had a dream, about which most today can remember, had recognized that for years he had heard the word wait, suggesting that it rings in every ear with a piercing familiarity, and opined that this wait, as always, meant never, suggesting that we must come to see with one of our distinguished jurors, that justice too long delayed is justice denied. And we are now, after over 3 years, bringing that case, that justice might flow like rivers and righteousness like a mighty stream for these children, and their right to an education denied that had once been considered perhaps the most important function of state and local governments, required in the performance of their most basic public responsibilities and the very foundation of good citizenship. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. And all we say to America is to be true to what you said on paper. Had a civil case been brought under VA Code 22.187 by a parent, a custodian, or legal guardian, it would have had to have been brought within just 30 days after the school board had taken its action back in 2020. And that action of the school board would have been sustained unless the school board had exceeded its authority, had acted arbitrarily or capriciously, or had abused its discretion. And many, during times historically associated with fear, confusion, and despair, may not have been able yet to formulate that argument back then for whatever reason. But we are prepared now to make that case. And under 18 U.S.C. 241, if two or more persons conspire to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any right or privilege, they shall be fined under this title or imprisoned not more than 10 years or both. At least according to the Supreme Court, such an opportunity where the state has undertaken to provide it is a right which must be made available to all on equal terms. And it is emphatically the duty and province of the Judicial Department to say what the law is. This message was approved by Major Mike Webb. Honest.